Hello everyone, I am Sidhant. This is the chapter 5 question and answer session of the public sector banks and the cooperative banks in India. Before starting, I would like to quote one quotation. Let's hope, let's believe, if this can happen, a lot can happen. This is a statement or the quote is given by the Harish Salve, who is the counsel of Kulbhushan Yadav case from India. He said this statement. There is a lots of positivity in this statement. That's why I quote this quotation here. So starting with the question 1, the regional rural banks are managed by. The answer is simple. The board of directors. That is, it is being done. It is being ruled or it is being held by the board of the directors. The board of directors are the person. It's not from the sponsor bank. As we know that regional rural banks are administered by the three participant, the central government, the state government plus the sponsor bank. So the board of directors is chosen by the combination of this or from the central government. Next question, as per which section the Banking Regulation Act applicable to the State Bank of India? As we know that the Banking Regulation Act came into existence in 1949 and in 1955 the SB Act was passed for the existence of the State Bank of India. So there is need to have the provisions of the State Bank, as State Bank passed with a separate is a statutory body. We all know that the State Bank is a statutory body. So there would be some mention in the Banking Regulation Act about the SBI. So in separately section 51 mentions about the State Bank of India as a banking company in India. Separate section 51 of the Banking Regulation Act. Though all the provisions of the Banking Regulation Act are also applied to the SBI. The minimum paid up capital for the commencement of the cooperative banks is rupees 1 lakh. The next question, under section 31 of the Banking Regulation Act. What is section 31 of the Banking Regulation Act? Returns, submission of the state cooperative bank, central cooperative bank, etc. Submission of what? The submission of the returns that we have discussed in the chapter. The returns of assets or CRR, SLR, lots of requirement, other norms. And to whom they have to submit? They have to submit to the NABARD. And NABARD will forward it to the Reserve Bank of India in case of the cooperative banks. Under which act? The Banking Regulation Act applicable to the cooperative banks. The Banking Laws Application to the Cooperative Society Act 1965. The answer is that. In the 1965, when the RBI wants to regulate the cooperative sector, it separately mentioned in the Banking Regulation Act of under section 56 that that cooperative bank has to follow the RBI guidelines or the norms, and so they passed this Banking Laws Application to the Cooperative Societies Act 1965 for the cooperative society only. Public sector banks in India comprises of nationalized bank, state bank and regional rural banks. These are the public sector banks of India. Undertaking first, SBI from Imperial Bank. We all know that. Next question, share capital of the regional rural bank distribution. 50% belongs to the state and 85% are distributed between the central or the nationalized or the sponsor bank. We will not call nationalized bank, we call the sponsor bank, because the sponsor bank could be a private bank also. The maximum authorized capital of the nationalized bank is 1,500 crore. We already discussed what is authorized capital. The maximum amount of capital that is being taken from the public by issuing of the shares is authorized capital. For opening of the branches, cooperative banks, application routed through NABARD. It will not be given directly to the Reserve Bank of India, though it will given to the NABARD, then NABARD forwarded to the Reserve Bank of India. Winding up of the cooperative banks is under section 35(4). This question discusses why the winding of the cooperative banks can be done. It could be done if under say 35(4), under 35(4) is the inspection. If in inspection something detrimental is found, then winding up of the cooperative bank can be initiated. Or second requirement, not fulfilling minimum capital requirement. The minimum capital requirement they have to follow, that is the rules and the regulation of the Reserve Bank of India. The third, that not entitled to carry banking businesses under section 22. In this, something is restricted or prohibited to do to the cooperative banks, but cooperative banks are adamant to do that or indulge in some of the activities which is not allowed in the banking system, then the winding of the cooperative banks can be initiated. The next question, the DICGC by the cooperative banks has to register with the DICGC. In order to have the provisions of DICGC applicable to the cooperative banks, then the cooperative banks has to register with the DICGC Act under 1961 separately. That's it. The module A of the legal completed. Thank you. Have a nice day.